All right. Good afternoon, everyone. Welcome to our timely topic with BrownWinick this year. This year's edition is on prenuptial agreements, and I can't really say that without smiling a little bit because I just think about the um, I don't know, interesting conversations that I can see happening between parents and children, and how these things kind of work their way into a conversation, as far as, hey, I'm going to get married, mom. Okay, did you get them to sign a prenup type of thing? And oh, what about a congratulations and first? Whatever, I see how it is. So anyway, I'm just thinking about prenups now a little bit more, and I don't know. I think this is gonna be fun. It's gonna be interesting, and we are recording this. We record these timely topic sessions, so a big part of this is to have a resource after the fact that we can point folks to for questions on what kind of can be kind of a little bit of a taboo subject, I would think, and maybe something that hopefully is somewhat hard for family to I don't know, bring up with others as far as that peer-to-peer part of things is maybe a little tougher with this topic. So,
I don't know what you're talking about, Dan. Every client
yeah,
calls, they're like, I
exactly.
can't wait to talk to my fiance about a prenup. My family's real excited about it. It's going to go great.
Yep, exactly. Can you feel the love tonight?
That's right.
All right. Okay, so with that said, I want to introduce Ben and Drew with Brown Winnick, and I'll let you guys just share a little bit quick about yourselves, and then we'll get into this, okay?
Yeah.
Sure. Drew, do you want me
Go
to
ahead, Ben.
start? Okay. Um, Let me see if this works.
Famous last words.
Yeah.
You mean the prenup or the slide deck?
How's that? Does that look all right?
Yeah.
Yeah, I think you have to start the presentation, but we see your screen.
Okay.
Oh yeah, I can see your gambling website in the background there. Premarital agreements. Okay, is prenup no longer the common nomenclature?
I think that's right. I think we like to call them premarital agreements at this point. And my understanding is this is a group that is generally comprised of business owners or um, people that
Yep.
want to be business owners, upstart business owners that so this presentation is sort of tailored um, towards those people with an understanding of kind of look, these are some issues you want to think about as a business owner, as a young business owner that's growing to be a bigger one. This is a financial tool and an instrument that you can use to protect you as an owner and your interests as an owner, but really, the business itself and continuity and um, clarity on how the business will be operated. So that's what some of the comments that are put together here are meant to address.
Perfect. All right, I'll let you guys introduce yourselves. Go ahead, Ben.
Yeah, my name is Ben Merrill, obviously. I have been a practicing lawyer in Iowa since 2008. I've been with the BrownWinick Law Firm since 2010. I am kind of a jack of all trades as a litigation lawyer here at the firm. Do a lot of commercial litigation work, construction litigation, employment litigation, but I also have some family law and work comp, personal injury type work. So I'm the jack of all trades as it relates to this type of work. And if you're getting sued or you need to sue somebody, chances are you might reach out to Drew, but that might call might come over to me. So
There's a
um,
decent chance.
I'm the guy that stands next to you in the courtroom if that, heaven forbid, happens. But with that, I have a lot of experience advising family law clients and business owners in this topic. So I think Drew wanted to include me for those reasons.
Definitely. Yeah, and my name is Drew Larson. I'm the same vintage as Ben, been practicing about 16 years. I'm sort of the Swiss Army knife slash junk drawer on the corporate side of things. Sort of like Ben, my practice is primarily corporate transactional work, working with business owners, primarily closely held business owners with everything from formation, financings, general contract negotiation, M&A, and then succession planning. So I do about a quarter of my practice is closely held business succession planning, estate planning, and all the related stuff. So that's how the prenups tend to come up for me. So I'll be working with a business owner on the business side, and either themselves, a child, someone like that, is getting married, and they want to make sure that they are thinking through what that means for the family business and how to protect the family and the business at the same time. So, yep, that's my background.
Let's
Okay,
get
and
into
this is our little BrownWinick talking point. Am I on the right screen there, everyone?
You are not.
Okay.
Oh, you want to show us your disclosure about how we can't take this as
Oh yeah, like we're lawyers, but don't believe a thing we say. The
Yeah.
standard disclaimer.
What a crock of crap. Okay. All right. Bold
So
solution.
that's right. See, doesn't that sound convincing? That's what we'll tell people when you ask your spouse to do the prenup. It's a bold solution. Just
Yeah.
remember that one. That'll go over
Sure,
great.
that'll put her mind at ease.
Right.
That's right.
Okay.
So let's go into what we're going to talk about here, which is premarital agreements. Again, through my experience with Drew and with our clients, this comes up often, and a lot of our clients at BrownWinick are business owners, but kind of smaller and upstart business owners. So this is particularly important for them.
And we're using the word marital here, but that's interchangeable with nuptial.
Yep.
Okay.
Correct. So what is it, first of all? I mean, this is primarily, and the way we use it in our practice is this is a financial tool for you to use and guarantee your protections as it relates to what assets are yours, what those assets will do either at your passing or at a divorce, and arrange a highly customizable system for you and your spouse to have an understanding of who can access those assets, what they look like, who has control over it. Really, it sort of runs the gamut on what we can do to set up your protections and tailor these protections to your particular business. There isn't a one size fits all on these premarital agreements. So if we have an understanding of what you need and what you want to do, we can probably tailor that agreement to fit you exactly within reason. So, I mean, this is a contract between two voluntary parties that are about to enter into an arrangement. So these are really strong tools for protecting certain assets, protecting some guarantees on how a business will be run, and really protecting the business against maybe a jilted ex-spouse or someone that wants to injure the owner of the business because of whatever reasons that might have happened. These premarital agreements can just provide cover in that regard.
All right. I've seen Tommy Boy, so I know it can happen.
Good example of when you should have had some protections in place. So this is a little quote I found. Don't exactly know who it's attributed to, but it's not my quote, just for my protection there. But it is really kind of what we think about when we enter into these premarital agreements. It's not that we think one of the two spouses heart is not in the right place, or there's not a sufficient level of trust. It's just a financial protection and to keep order and continuity between the parties.
Yeah, that sounds nice and warm and fuzzy. I like that, Ben.
Yeah. I mean, the fact of the matter is, as everyone knows, I think the statistics are, 50% of marriages end in divorce. And even if you didn't end in divorce, if you have a business and you, God forbid, something happens to you and you pass away, you probably have co-owners of the business, or at least people with interest in the business, that don't necessarily want to see your spouse, he or she, whoever that might be, have all this control of the business after the fact. So it really has nothing to do with whether or not you love the person. You might know that you're going to be married forever, but forever comes too soon because of a tragic accident or something like that. That's why these protections are so important.
Okay.
So some things to know, like legally, for these premarital agreements, they have to be they have to meet certain conditions or certain forms in order to be treated as enforceable. They have to be in writing, signed by both prospective spouses. I usually encourage, while it's not necessarily a hard and fast rule, I usually encourage counsel to have reviewed for both sides. Um, this is all under the scope and under the filter of we're trying to make sure it's as enforceable as possible when it needs to be enforced. So if you have counsel looking at it, any sort of agreement from both sides, there's sort of the idea that you were fully informed about your rights. You were fully informed about the obligations of this agreement. You understand what it means, and so it has more enforceability when lawyers are present. So that's kind of the idea of that. Obviously, it has to be signed voluntarily. You can't, coerce or under duress get your spouse to sign. That won't be enforceable. It also has to be not unconscionable. So whatever the terms or the directions that are provided in this premarital agreement can't violate public policy or can't go so far as to make it you know unworthy of being enforced by a judge later. That would be a problem. And there's some cases that have come up recently from the Iowa Supreme Court that talk about this, it not being conscionable. I've underlined this next bullet point because I think this is really the most important part of this slide and screen. It's the part that comes up the most with clients. It's this idea that each party has to have a fair and reasonable disclosure of the property and financial obligations of the other spouse. So what do we mean by that? You can't enter one of these premarital agreements and have it be enforceable if you don't know what is being carved out of the marital estate. So you might understand that your spouse has a bank account or has a business, right? But if you have been given no opportunity to understand what that bank account is, how much it's worth, or how much is in there, what a company is, how much the company is worth, then it's harder to say later that you knew what you were signing and you voluntarily signed or agreed to carve that out. So, Drew might have entered one of these with his wife, but he told his wife that he only had $1 in his bank account. And she's probably like, fine, I don't mind you keeping that dollar if something happens later. But if he really had $1 million in there and he didn't tell her that, hard to say there was a fair and reasonable disclosure of the property that is being included in this premarital asset.
Okay. Do you see where they actually list out the assets?
Exactly right, Dan. So how I like to do it is I have it's either in a amendment or a standalone chart in these
Yep.
agreements that say I have this many bank accounts under this, community state bank or whatever,
Mm-hmm.
and this is the value of that account at the time of execution. Uh, it really is necessary, and it doesn't have to be precise, right? It doesn't have to be like down to the penny, but it really is necessary to give an understanding of what that account is. So if you have 401k accounts, for example, you probably shouldn't just say the 401k account from principal. You should say the 401k account from principal that as of, April 2025 is worth 50,000, for example.
Sure. Okay.
And that the challenge with that, Dan, really comes in when we're talking about these closely held businesses or small businesses. How do you value ABC, Inc. or ABC LLC, that you don't really know if it's worth anything at all? And that's, frankly, as an advocate for my clients, that's where we're discussing pros and cons of putting a value in there that we can support later, that the evidence suggests is right, but also puts my client in a better position to protect as much of their company value as they can, for example.
Okay.
Does that make sense?
Yeah. I might have more questions down the road, but I get what you're
Sure.
saying.
Sure.
And
And again, really depends on the actual assets that these people have, right? I mean, it might be very simple and straightforward with a bank account. It might be much harder when we're talking about potential inheritance or real property and how that's valued, or again, closely held companies and their valuation.
And it's worth noting again, like these were for a long time illegal. Most states have now allowed them before marriage. By default, they're not permitted after marriage. You can't sort of decide after you're married, we're going to agree to this. It has to happen before you actually get married. And the courts look at them somewhat skeptically because they want to protect the weaker party. And the reality is the weaker party is generally perceived to be the party with less resources. So that's where, I know I've had clients where we have paid for the new spouse's lawyer to have independent counsel because we do want this to be enforced. And where our worry is if they don't have counsel, later on, they're going to say, I didn't understand. I didn't have this information. I didn't comprehend what this really meant. And we want to get ahead of all of those arguments because those are the ways people attack it on the backside is it's truly unconscionable. It's unfair. You didn't share. I didn't understand it. I thought it was $1 million. I didn't understand it was 10,
yeah,
right? And giving that sort of scope.
Yeah.
will we talk about timing down the road? Like, is there a TFL type of date where, we're getting married on Saturday and it's Friday and I'm asking you to sign this thing? And does that
There,
still feel like voluntary? And does that still feel like whatever?
exactly, Dan. And there isn't a hard and true, we can just talk about it now. There is not a hard and true date that like a week before the wedding, it has to be done.
Yep.
Um, but obviously, the closer you get, and the more rushed it seems, is opening up all these arguments that Drew is talking about enforceability and voluntary. If you don't have this drafted up and reviewed by the other side and hopefully reviewed by counsel in enough time to meaningfully think about it and sort of sit on it, you're just opening yourself up to enforceability arguments, right? So I've looked at that a lot recently, Dan. There's no hard and true date because that's your question is like the first question most clients ask, right? Uh,
Okay.
when do I have to get this done by? But I just encourage, I mean, I'm talking to a client right now, even who's I think his wedding is set for later in May. So I've encouraged him, like, let's get on it right away because, we don't want to run into any, 11th hour, please sign this or else. That just opens up, enforceability arguments.
Yep. Okay. Okay. Thanks.
And the last point on this slide is a point that I think is important for clients to understand too. While these are very powerful tools, there are limitations. We can't do things like contract away the right of the other side for spousal support in the future. We can't contract away the right for the other side to get child support. Those are just a couple examples of things that we can go pretty far on these premarital agreements, but we can't go that far. So when those questions come in, it's important for clients to understand, what would make it unenforceable, and something like that would be a no-no.
And spousal support, just people may be more familiar with the term alimony.
Yep.
That's another phrase used for spousal support.
Yep. Okay.
Yeah. In other words, I mean, you can carve out assets that you get and your spouse doesn't, or if something happens and you pass away, those assets will be held in trust in a certain form or fashion, but you can't get rid of the concept or the right of your spouse to get spousal support. It might
Okay.
it might factor in later on how it's calculated, but the right is still there.
Perfect. You've been talking a little bit about the attorney side already, but sometimes people like to watch a YouTube video. I might be in this camp as well and create my own little prenup. Let's just say. I'm guessing based on what you're talking about here in terms of enforceability that that's probably not going to fly very far with a judge if I write something up on a piece of paper and have my future wife sign that type of thing.
Yeah, what do I like to say? And Drew, you might have a saying for this kind of thing. We deal with this with like people who just did their own wills and that kind of thing, it might be fine. It might be enforceable. Do you really want to run the risk of that though? And are you saving that much money long term? If, I did this myself, so I didn't have to pay a few $100s to my attorney to do
Yeah, a
it.
little attorney fear there. I like that. It's good marketing. Okay.
I just,
Well, it's like anything. I mean, what I'd say is, Dan, for your $50 to your name, I
Yeah.
think you're welcome to roll your own, right?
Okay.
But
Okay,
if the
good.
stakes are high enough, right, I think
Yeah.
it's worth the investment because it gives you a lot of freedom. And it's funny because like Ben's going to talk about what can be included, right? But in many ways, it doesn't mean that you will do this forever, that this is exactly how you plan on distributing the property forever. You have some flexibility later, but it puts the control of that in the party's hands that wanted the prenup, right? So the family's hands, or if
Yeah.
I'm the one that owns the business, I retain control over my choices there, even if later I may decide I want to leave something to my spouse because we've been together for 60 years. I preserve the flexibility to make the choice as opposed to the law making the choice for
Yeah,
me.
right on. Okay, good point. Okay, thanks. I'll shut up. Yeah.
no, that's good. Um, so and these are just some examples that are most often included in these types of agreements. I can let the audience just sort of review these, but some of these probably are more obvious. That second point, the right to buy, sell, use, transfer, or create a security interest, mortgage, encumber certain property or control. I mean, that's often an important part of these agreements. You don't want, you know you want the one person who's running this ship or running point on this thing to be able to do those things. And you never, it doesn't mean you don't love or trust your spouse, but this is the way to keep that asset preserved. Not just that I get the asset, but I get the control of the asset.
Hmm.
Um, you know, uh, that fourth point, the making of a will or trust or other arrangement to carry about the provisions of the agreement, to carry it should say to carry out the provisions. I mean, the point is, I might say I want to handle this property in a certain form or fashion to limit, distribution or tax consequences. And these types of agreements can allow you to set it up and create a trust or create some other arrangement that our estate planning group can help with to make sure this is effectuated as intended. Um, and this ownership rights and the distribution of death penalty, that's a big one too, because again, we often don't always have a great either will or trust set up at the time of our death for whatever reason. If you have an unexpected death, if going into the marriage how you want life insurance policy benefits to work out, this is a great way to put it in there to
So
kind of set expectations.
you can kind of execute some of your estate planning through a prenuptial agreement as well, then.
Definitely. I mean, frankly, I'm a litigation lawyer. I deal in this space when people are upset with each other and it's broken down. In anticipation of this talk, Drew and I, both talked to a few of our estate planning lawyers. They're dealing with these agreements all the time. Because often, one of the parties going into a marriage, is trying to set everything up as well as they can in advance of that marriage. And the estate planning group has all sorts of ideas on documents and trusts and language in the trusts of how you can do that.
Okay, great. Okay, perfect. Thanks.
Little plug for that group.
Sure.
To Drew's point earlier, um, we can always revoke these agreements. So there's certain ways they have to be handled. It has to be a written agreement by both parties. But, the law recognizes that people's situations change and people's feelings about a certain asset or feelings about their spouse, might change. And certainly you can go in later and say, all that stuff that we had premarital, I think we should get rid of it. And, we have a different system set up now, either through our trust or our other will instruments that is going to be fine in protecting these assets and fine in protecting the party's assets. So we definitely allow you to go in later and revoke these premarital agreements.
Okay. Okay.
But one thing I noticed in preparing for this, there's a case that's about a year old now, the Roberts versus Roberts case, Iowa Supreme Court. And what that makes very clear is we're not going to let you during the marriage come in and sort of rewrite these premarital agreements. Now, to Drew's point earlier, you can always handle your assets differently, right? And you can always come to an agreement on how this is going to work. But in terms of going in and revoke and amending or otherwise sort of revoking certain parts of the agreement, the parties in Roberts, they called it a partial revocation of the premarital agreement. And what the court rejected that quickly and said, look, we know what you're doing. You're trying to amend this premarital agreement. And the point is there's no consideration and there's no proper authority to allow you to go in and change an agreement that you both agreed to at a certain time prior to the marriage. Because that's prior to the marriage, that's what you guys had in mind. That's what you guys wanted to do. That's the way this is enforceable. If to change it now for these other extenuating circumstances suggests that, it's not an agreement that has consideration and is enforceable. So again, we're allowing these premarital agreements to be revoked or abandoned, but we're not going to let one side stand in court and say, yeah, we had this agreement in April of 2025, but 10 years later, the parties actually don't have that agreement, and I actually think it should be something else, because the only reason it hits the court, right, is that you don't have that agreement, right? So the fight shows that the agreement isn't what one of the two sides thought it was. So courts just don't want to mess with it. Courts say you can't do that. And if you're in front of me fighting over this partial revocation of this premarital agreement, that means that you don't have an agreement.
So basically, it's either enforceable in full, or you decide to drop the thing pretty much entirely as you go through your life with your spouse.
I think that's the way you should view it as an agreement.
This isn't a living document that can be edited over time type of thing.
Correct.
Okay, cool. Or now that I've decided I trust you, I'm gonna, whatever type of thing.
Exactly. You've done your time, so now you get more of the asset. No, you can't do that.
All right.
Yeah, you can. To Drew's point, you can do whatever you want, with your family, and you decide what your assets are. But when it comes to enforcing that agreement, that's something you can't do.
Mm-hmm. Yeah, which leads nicely to how this is actually used for succession planning and as part of a broader estate planning, transition planning structure for a family and their family-owned business. So yeah, hit the next one if you would, Ben. So why are they important for business owners? Well, you've already heard, we already know one asset that is particularly important. This is true, especially in states like Iowa with lots of privately held family businesses all across the state, is those are significant sources of wealth in the family. They are illiquid, and the close management and the desire of the family to keep it in the family is usually quite high. And so while obviously everyone wants their child, if they get married, to have a long, healthy, loving relationship, right? We know if we have enough kids, grandkids, or whatever, the odds are this is going to come up. And almost everyone wants the business to stay inside the family and their descendants when they built something like that. Mm-hmm. So the prenup is a supplement and part of your general estate plan. So for example, if I were the founding generation of a business, I would often have a buy-sell agreement, for example, that's going to provide that if any asset tries to transfer outside of my family, whether it be from bankruptcy, divorce, voluntary transfer, often I'll prohibit that transfer. I will I'll have a right to buy it out first, a right of first refusal, or various other protections that allow the other family members to make sure they hold on to it or get to keep it. What I tell people is if there's a buy-sell provision like that, and me and my wife were to get divorced, most likely the court, when allocating assets, even without a prenup, would probably put the family asset in my column and they put other assets in my spouse's column, right? As they try to do a fair and equitable distribution of those
Sure.
assets. So where does the prenup come in? The prenup would say is, hey, we're going to decide. Now, it can be written in lots of ways. It might have a very specific, at my death, this person gets this, whatever, right? And that's often what I'll call the baseline. It's the baseline agreement. And it usually will say that me as the party that owns the business, I get to decide what happens to my business. At my death, at any time, I control it. My spouse has no right to demand it be treated in any particular way. They have no right to it as part of a property division, etc. So even though we have the backup of the buy-sell, this basically says we hopefully never have to get to the buy-sell. We're excluding it from the marital estate from the start, and it's just not part of the property the court's even going to consider in division. Go ahead, Dan.
Does that mean then that, like, I haven't been divorced, but if you get divorced and they're doing the settlement, they do this 50-50 thing, whatever it is, they pull that, the business,
Not in the pot.
it's not even in the pot of consideration.
That's the point. Yep.
Okay.
And so
And
that's the layering on here. Yep, go ahead, Ben.
honestly, Dan, I mean, I can't tell you in working through divorces with some of my clients who are sophisticated business people that they just can't wrap their head around, well, how come this is my company for 20 years? I did all the work. I built it up. My spouse didn't have anything to do with it other than, being my spouse. How come that's considered as part of our, marital assets that have to be divided in an equitable, often 50-50, but not exactly manner? Well, the answer is because without a premarital agreement, it's a marital asset.
Okay.
Yep. And so these premarital agreements give the control back where we want. Now, so let's actually go to the next one. I want to cover this. I've got something to note, but I think the next one's good. So what should be included in this agreement? It's not just the business. One of the things that's important to note is the courts, and again, there's lots of variations on this, but they look at the marital property, what you own as a couple. Like it might be what you started with, but it might also be like, what does it grow during your marriage and all that. Your prenup should and premarital agreement should cover all of those things. The business, its growth and appreciation, the proceeds from the sale of the business, the successor business, all of those things, right? And often there'll be separate property. It might be real estate related to the business, all of those things. We wanted to say that sort of the business and all the things that come with the business that flow out of it in the future, all of that, those are all separate property. And me, as the founder, owner, get to control what happens with that separate property going forward. So you'll see that that's sort of covered there. If you go to the next slide.
And Dan, just one point to that, that's probably to your point about, can I just do this on my own or should I have a lawyer? I've seen these premarital agreements that just say like the business, okay? The problem you run there, to Drew's point, is if you don't have certain language about, increases in value and successor business as part of that.
I sold it, I merged, I got 20% in this new business. Does that count or not?
You run the risk of it not being included in the premarital agreement if you just say the business, for example.
Yeah, okay.
So we talked about what does the non-business owner prospective spouse get? Well, they get some asset protection. We want to protect that spouse from all the liabilities coming from the business. Maybe the home is separate from the business-related debts, some other things like that. And generally, it just keeps those business interests separate from the personal interests. Again, that part of that is contractual, part of it's not. You'll also see that sometimes you'll have things like, I wrote a prenup once where the person who was entering had already made a good amount of money, but was fairly young. They wanted the marriage to work well. And they had some money, but it wasn't massive, but they wanted to basically increase the dollar amount up to 50% over 15 years. The thought being, if we're together 15 years, this person had made their wealth themselves. So it wasn't inherited wealth or like a family business yet. But the idea is like, look, I'm going to increase that number every year. If we've been married one full year, they're going to get 2% of my separate property. If we're married 25 years, they get 50%. And like by that point, it was just like the thing sort of lapsed and they called it good. But that was the model they worked out among themselves and asked me to draft. So we sort of built out this sort of model where it's like, hey, if we're together that long, you know what, the rules are just going to apply the way they would normally fall. But they wanted some protection of the quick divorce, right? Like we want to have a clear sign. Some people will buy life insurance or other, like have a fixed number. My spouse is going to give $1 million, right? On my death. If we die and we are married, $1 million, and then the rest of the separate property is going to do that. I'm sure Ben has negotiated as many variations as I can imagine
Yeah.
on those themes.
That would be listed in a prenup as well, like what life insurance proceeds.
It can be, yep, specific things. And see, that's often what you give to that other spouse is what is the commitment? You know, is it just I'm signing away everything, or are we also making a commitment about if we do get divorced, what can I reasonably expect? And sort of helping to frame that out a little bit.
Not only what am I going to not get, but what am I going to get?
What am I going to get? Yep, potentially.
There's a lot of negotiation that can happen within there.
That's exactly right.
There can be, yeah.
Wow.
And this sort of builds to this next slide, Dan, that Drew, I'm sure wanted to highlight, but I want to highlight
Go
too.
for it.
You know, without these agreements, you kind of run the risk of the disposition of all these assets that you have will be at, frankly, what I call the worst possible time, right? So if you don't have an agreement that lays all this out, guess what your spouse wants, you know, when you're negotiating your divorce? Pretty much everything he or she can get, right? So if you have this plan that like it really makes sense for me to have this asset, and she agrees in a time where she or he agrees in a time where you're copacetic and you know heading into a wonderful marriage, get that in writing and get that agreed upon, because you know what he or she is not going to agree to that same thing when you're getting divorced. They're going to I've seen it before. I'll see it again. They're going to ask for everything that they can possibly get, and they don't give a you know what if it was your business all these years and he or she didn't have anything to do with it. They want their cut. So,
Okay.
Yeah. So I think that's exactly right. And I already mentioned how this relates to other estate planning pieces. But for example, let's just say your parents set up a trust, a generation skipping trust for you, and that trust exists and it's going to go to your kids after you die, right? That's actually not your property, right? So already like the prenup may or may not cover that. It probably wouldn't by default because it's not your property. Now we might mention it and say, I have this trust. I'm a lifetime beneficiary. You're not entitled to those benefits. The trust will also have protections about this. This whole area is about belt and suspendering, right? Lots of protections to try to cover from multiple angles the same sort of issue that comes up. So, you know, families are going to look at trusts to do multi-generational planning and protect. They're going to have the buy-sell I already mentioned to protect if something does get transferred. They might have a prenup to protect the growth in the existing property held by that person who's entering into the marriage. And I want to talk about, so like that's all the protections. We build all of this estate planning structure about protecting the business and the family that starts with the assets, right? Now, what I'll tell you is there are lots, for all the ones we worry about, the divorces, there are lots of long-term thriving marriages, right? That happen and are work. So what happens in those cases? Well, often I would say I would very rarely, if ever, probably suggest revoking a prenup. Like I just don't think it's going to happen. What the prenup will often give the person the flexibility to do. In my case, if I were the business owner, for example, the business owner, just because the prenup says, I have the right to decide everything I want to do with this business, right? And its proceeds, for example. That doesn't mean that I couldn't potentially leave that in a trust by my own volition to a spouse, or the proceeds, or a life estate, assuming the buy-sell permitted it and other stuff. Right. Or if I had I had $5 million in hard assets, just cash, we'll say, in a bank account, and that's supposed to stay mine. It doesn't mean during my life or at my death, I couldn't put in my will, my spouse can have that $5 million. I have the power to make that decision. The prenup gives me the choice as opposed to a court on divorce or other things. So it's
the
really
will or the estate planning would overwrite the prenup.
It gives, if I express my wishes differently, I have the power to choose where the assets go, and my estate planning can direct that. And it may be different and more generous than the prenup was,
Yep.
especially if I've had, you enter into a prenup at 22 or 23 or 25 or whatever, right? If I'm at 65 and I've been with that same spouse that whole time, there's a pretty good chance I'm going to do what most people do that don't have closely held businesses, give it to my spouse, then my kids,
Yep.
right? Or in a family business, it might say give the spouse the non-business assets, the business assets, whatever.
Yeah.
By that point, they're not thinking that they may not be thinking about the prenup that much. But I like to leave it in place in case. God forbid something happens, we've got those protections. But because occasionally I'll get that question, does the prenup mean that I'm really like, if I have a 50-year marriage, I'm not going to leave anything to my spouse? No, that is not necessarily what it means. It means you might have the ability to. It doesn't mean that's what you will do or should do or have to do.
Okay. Okay. Um, I see your question slide there, so I
Oh,
assume we're getting close to the
yeah,
end.
that is the next slide. So questions it is, my friends.
Yeah, let's just talk through the scenario of founder Frank. Use him often, and he starts a business. He has three kids, and his estate planning is in his thought. I don't know if he's got it written out or not, but he's going to essentially divide that company up three ways between his three kids. And maybe only one of them is working in the business. But he wants them each to have a piece of this business, for whatever reason, that's, whatever. And can he, so what he would maybe advise, or what he would try to create with his legal help, would be a prenup that he would hope to get his kids to sign with their significant others, that might just simply pull the business out of the asset pool.
That's
Or,
correct. I think it'd be belt and suspenders. If I were talking, if Founder Frank came to me and they said, I'm thinking about giving, I want on my death this business to go to my kids, I might start gifting some even before then, right?
okay.
I would probably have a few pieces. I'd talk to them about, well, okay, we have a buy sell in place, even if you haven't given it to them yet. Before you give them stock, let's get that in place. Let's talk about how to get it to them. If you were a taxable estate, maybe we've got some trust, we've got some other tools. And yes, we should talk to your kids if they're unmarried. If they're going to get married, we should consider asking them to get prenups so that if we do give something to them outright, not in trust or some other structure, that this is protected upfront on a go-forward basis.
Okay. Okay. I got a couple questions here that have come in. So,
Yeah,
Ben was talking about disclosing and making sure everything is disclosed and listed as far as assets. Does that work the same way, I would think, with like debts? Like if we forget to put in there I don't know, whatever, $250,000 debt we have on XYZ thing, or whatever, or credit card debt, or whatever that debt might be, that if we forget to, or casually omit that from there, is that I'm assuming that isn't going to be whatever in your best
Right.
interest.
Yeah, what I would say is if the parties intend to have this debt, stay under the ownership or control of one of the two parties, um, identifying that debt to the best of your ability and putting it in there of how you want that done should be done, if that makes sense.
Yep.
I mean, I think you really want the full balance sheet or net worth statement, whatever you want to call it. That individual balance sheet is important.
Okay. A couple more questions here. Is it pretty much always in the event of death or divorce within a prenuptial agreement? Are there other end circumstances that are trigger points in there, or is that's basically it, right?
I think so. I can't think of, what about
Yeah.
you, Drew? I can't think
I would say
different.
yes, like they are specifically built again because you otherwise the default is you have the control otherwise,
Yep.
Mhm.
right? So like this is really about times when arguably you wouldn't have control as much on death, but really about divorce. You have less control over that process. This is about making sure who has control of that property. So yeah, I would say that's really the primary concern. It's not dealing with bankruptcy issues. It's not dealing with those kinds of things.
Okay. And then another question that we got is uh, related to this in the way that so you're talking about all the other estate planning that Founder Frank might do. Is it this this webinar, this topic was meant to be about what is a prenup and how do they work, and not so much about how the heck am I
Yep.
going to talk to little Jimmy and Sally about my kids about how to they
Mhm.
have to now ask their girlfriend, boyfriend to sign one of these. Um, that's a whole nother can of worms, right? And a whole other topic
That's
of
right. These
conversation.
things
But
all dovetail together, like they are all part of a broader system to
yeah,
try to provide multiple layers of protection for these kinds of.
yeah. And so I don't want to go. So we're not going to go down that path with this topic, but maybe we could. Their question is, what are there other ways that we could protect the business just as securely? Um, that maybe wouldn't be as I don't know, traumatic.
Yeah, it like let's just say it ties actually nicely. Tim asked a question in the Q&A about a business owner. Can we require this in the ownership agreement or a trust with the kids, right? To force them. So yes, I do see that occasionally where it's like, if you want to receive shares, you need to have a prenup. We expect any owner to get a prenup with respect to their shares. Now, is that necessarily enforceable? I don't think you can like claw the shares back, or I've never seen someone try to be that aggressive. But I have seen, and I've added that language into those documents so that the kid has something to point to saying, I sort of have to, mom and dad, grandma and grandpa are making me because I'm an owner of this business, right?
Then it
So
gives them an escape clause to blame
that's
their parents
exactly
or their
right.
grandparents and say, well, the old man is making me do this. Sorry,
So
he's a
that's right. Now, like, what's the consequence if they don't? If usually what the family says is, well, we're not going to give you any more if you're not going to get this done. So that's the hammer, the threat. It's harder to pull it back from someone, but it's not necessarily impossible. But I've never seen anyone go quite that far. And Dan, it ties to your question is like, what if we don't, like, it's so uncomfortable to deal with the prenup question, right?
Yeah.
A
yeah.
generation skipping trust where it never becomes the asset of one of the kids, then it's never in the marital estate. It's never the spouse's. And that is a way to like, you don't have to deal with it until it ends up in someone's individual hands later on. But a trust can be used to kick that question out a long time. Now, generally, there are some states that allow forever. Iowa's is nearly forever. I mean,
Yeah.
it might as well be forever. It's 100, usually with with how long people live, maybe 100 to 125 years before they have to wind up. It can be a long time. But fundamentally, it's a long period of time where you might be able to punt and not require this. Again, now is it a layer in case something happens? People do change things over time. I sometimes like to have multiple layers, but yes, the trust could avoid this depending on your trust structure.
Sure.
Okay, and I don't know if we have time for this, but so I'm hearing about the generation skipping trust, as a tool to maybe supplant the prenup and the awkwardness of a prenup potentially. What's the downside of, if any, of that?
Yeah,
User.
significantly more complexity, right? Like
Mhm.
for those who've ever had to deal with trust, either their own or their families,
Okay.
right? It's another shareholder. It's got its own set of distributions. You might have multiple generations of them. There's a certain complexity and cost in managing them, maintaining them, making sure you're being really careful about who owns what and when, and just it's more challenging. Now, there's other tax reasons that might lead you down that path, right? So there's that. But if you're already going down the path, you are often going to do the kinds of things that deal with this prenup issue as you're doing sort of like advanced tax planning. But if you don't have any of those things, maybe it's not a taxable business yet. Let's just say it's worth 10 million.
Sure.
It's not going to necessarily be taxable. The prenup's going to be a much cheaper option to deal with this in the early, like upfront, than doing a full trust structure. And well, like you won't have to think about it as much going forward. The trust you're going to think about a lot.
Okay. All right. Perfect. I'm glad you mentioned that. So like,
Yeah, and in that case, your son or daughter owns the asset or controls the asset. If you put it in trust, it's the trust, right? So there's all sorts of limitations on what, your son and daughter might be able to do later that it's too varied to talk about right now. But the point is, um, getting a trust involved requires all sorts of different considerations and complications, to Drew's point.
And it's okay, so it's not like some silver bullet preventative of having to have the prenup type of thing. It's
Not
got its
necessarily.
own set of hair on it, so to speak, type of thing. So okay, all right. Um,
Another thing, Dan, I like about these agreements is from my experience as you know, the family law lawyer, standing next to my clients in front of the family law judge at the time of the divorce. What I always feel compelled to tell my clients is these judges, they don't have any emotion as it relates to these assets. Okay. And what I mean by that is they don't care that this was granddaddy's business, or they don't care that the car that's getting split up was the car you inherited from your father when he passed away. Um, I guess, you know, unless there's certain limitations there that makes it fall outside of the marital assets. Um, they are looking at what's the total value of the assets, how can I split it in half or close to it, and how can I give all of these two parties half or again close to half of these assets so they can get out of my courtroom. I mean, that feels harsh for some people to hear about, you know, their livelihoods and their
yeah.
assets, but the judge doesn't care. And so if you have one of these agreements and you really want to make sure, you know, wife or husband or whomever is getting this asset post, you know, this relationship,
Mhm.
it protects that. And otherwise, you run the risk of standing in front of a judge, and a judge might say, you know what? I'm going to order that you sell your interest in this company and split it as part of the way that we resolve this dispute. And that's almost never what the parties actually want to have happen.
Okay, perfect.
Yeah.
Things we've talked a lot about the family business, but other assets that are commonly thought about in this is if you have like a longtime family farm that's been in the family for, you know, since the settlers or something like that. That's one that often might be inherited by even like the party that maybe doesn't have the close sale business. Those are common stories where both parties might have some asset. Even if it's just an investment asset that they're cash renting, like that farmland that they want to stay in the family. So it is not uncommon that both parties have something that they want to make sure stays in their side upon a divorce.
Okay. As we wrap up here, I realize this is a very fringe subject. You know, hopefully doesn't, I mean, it doesn't impact a lot of folks, but would you say in general, you know, second, third, fourth generation family owned businesses that have some scale to them, this becomes a not so uncommon tool, like uh the kids in those families, you know, shouldn't think of this as this way out there thing that their old man is pushing on them that seems incredibly unfair to ask their girlfriend to sign. Do you get where I'm going with that? Like,
Yeah.
Yeah. I I think so. I've been doing more and more of these lately, and again, that quote that was on the slide earlier, it's just a tool for business continuity and business certainty. And to Drew's point, that I think is a great point, you can always provide either in your will or your trust documents that your spouse gets these assets. But these premarital agreements are just ways to control, to maintain the control of that asset,
yeah.
right? And that's what you want more than anything. It doesn't mean you don't love and trust your spouse. You just want to make sure you have that control.
Okay.
Yeah, and I would say I agree with Ben. The one thing I would say is I actually would say for like a fourth generation business that's been successful enough to make it that far,
Yeah.
I see it sometimes, but actually less often because I think they tend to have much more complex trust structures and all that, where like the value is declining. A lot of it is if I founded a company now, I'm 41, but let's just say I wanted a kids join me in their 20s
Yeah.
and I wanted to start giving them stock. You
Mhm.
know, often I'm not big enough to like want to set up a trust or any of that. So I often see it in that first and second generation where
Oh,
they own it outright.
Yeah.
Maybe the kid came in early and before they're married, and before it blows up or is it starting, like that tends to be a really good and critical time because they already own the stock themselves. It's not already protected by some other tools,
sure.
and we're going into this and we can see the value being built.
Okay. It's actually maybe a little more common in those scenarios where
At
there
least
is.
that's where I have tended to run across it. It's
Mhm.
a startup founder, first or generation owner that is like sees it starting to grow and wants to protect it as they or their kids start getting married.
Okay.
Yeah.
I got one more question too that got texted to me that I want to
Awesome.
see if you could address this too. Can you, when you, if you've got a business partnership, if you and Drew, you guys are in business together, can you somehow require a prenuptial, I mean, I suppose you can't if they're already married, but if, like, let's say Drew's not married, could Ben require some sort of a prenuptial, thing to happen if Drew were to find Mrs. Right type of thing down the road or whatever? You get what I'm saying there?
Yeah.
Yeah. I
Go
don't
ahead, Ben.
I think so. I don't see any reason why you couldn't do something like that. If you run into that when you're forming companies or partnerships, Drew, with your clients.
I haven't actually run across it often. Can I, again, I think it's like I said with the trust. Could I imagine where we put that in there as a requirement? I think the question is if I say, Ben, we've been partners, this is going well. I'm not making my wife sign a prenup. What are
Right.
you going to do? I think it's really hard to be like, we're going to blow up the business, we're going to force me out if the business is otherwise going well, right? So
Mm.
I think a lot of people, I think they want to set the standard where that's an expectation. The enforcement becomes really unattractive, I think, to most people when the time comes. And there's not, if I'm already in it, there's just not usually good alternatives to like making me sell my shares or leave
Okay.
the company. Like, is that a win for the company? Probably not. I don't know, Ben, maybe it is. This is my tool to finally get rid of it.
Yeah, right.
But
Right.
Okay. Okay. No, that's good. I'm glad you covered that. I think that's all the questions that we got. So, um, yeah, this is cool. I learned quite a bit here. And I really appreciate it. Appreciate you guys' time sharing this. Again,
anytime.
we have this recorded, so we're gonna share this around, of course, and keep it around. And thanks to everybody who attended today. We've got some events coming up, so check our website for those. And Drew, Ben, thank you so much for your time, and have a great rest of your afternoon.